Great. Thanks for joining us today for our webinar entitled Your Employee is Pregnant, Now What? Understanding the Relevant Leave Laws. My name is Denise Petty, and I'm your moderator for this session. And I just want to run through a couple of quick housekeeping notes before I introduce our expert panel for today. The webinar runs approximately 55 to 60 minutes. We will save some time at the end for a Q&A. Don't worry if you need to leave before the webinar is over. We will post it on the Ethos HCS YouTube channel page and also the Merhab, Robinson, and Clarkson YouTube page. Please take a moment now to download your handouts. They'll be on the next slide. Okay, take a moment now to download your handouts. I'll keep posting them. If you missed this right now, I'll post it in the chat once I'm done speaking. If you have any questions during the presentation, please post them in the Q&A area on the dashboard anytime during the presentation. If you want your question directed to a specific panelist, please note that while you're sending in the question. Just a reminder, today's webinar is being recorded and all accompanying materials are protected by copyright. Our presentation today is intended for information purposes only and should not be relied on in reaching a conclusion in any area of law. The information offered in the webinar is good as of today, April 13th, 2023. As always, we recommend you consult your own legal counsel to address your specific situation and ensure you have the most current information on your legal matters. Today, our webinar has been approved for 1 HRCI credit. If you are certified through HRCI and you want a credit for today's attendance, type in HRCI into the question section on your dashboard and we'll send you a certification. There's also a survey. If you don't catch that now, I'll post it towards the end. You will need to complete the survey. Let me introduce you to today's panel. Our legal expert today is Curtis Urian. Curtis is an associate at the law firm Merhab, Robinson, and Clarkson in the firm's transaction department, where he advises clients in real estate, finance, and employment law. In addition to all the work that Curtis does, he contributes articles to law journals and lectures in the business and political science department at the American Jewish University in Los Angeles. Curtis has also been recognized as a rising star by superlawyers.com for the last 7 years. Our human capital expert is Linda Duffy. She's the founder and president of Ethos Human Capital Solutions and is known as the people problem solver. Linda and her team are known for building the magic of the human connection with their consulting, recruiting, and training and organizational development programs. Linda and the team work with your company by developing strategies for business leaders to get the right systems, people, and culture in place in your organization. So as a business owner, you can focus on running your business and achieving goals. Thanks to Linda and Curtis for today's session. And why don't you guys take it away?
Thanks, Denise. Welcome, everybody. Denise will be dropping the handouts into the chat. So if you haven't already had the opportunity to get those, you can. Of course, you can always get them after the fact as well, but just wanted you to have the opportunity to follow along and take notes if needed. Today's agenda is pretty straightforward. We're going to talk about the leaves of absences as they're related to pregnancy disability leave. Curtis and I were talking earlier. We both feel like there's still a lot of confusion out there about how the leaves interact and what benefits there are to employees under each of these different leaves. So we're going to talk a little bit about that. When we talk about leaves, there are a whole bunch of questions we have to sort of consider as we do it. So for example, what is the company required to provide? Because not all leaves, the requirements on the employers of who has to provide such a leave. If you have 20 employees, you might be subject to some. If you have 50 or more, you're probably subject to all of them, right? Some kick in at 5. So when is those levels? And then we're also going to look at, are the employees eligible? Because sometimes there's a requirement on the employee in terms of the length of service, or maybe, a specific qualifying event of some kind. So we're going to talk about that as well. We're going to look at how much leave must the company provide, and do you have a requirement to reinstate the employee once they're back from leave? And then also if the employee has to provide you any sort of notice, whether you can force the use of vacation or sick, and how it impacts other benefits. So those are sort of the things that we need to look at when we're talking about the different leaves. So Curtis, let's get it kicked off with pregnancy disability leave. Maybe you can start by talking about what disabled by pregnancy really means, because as we know, it's not necessarily just the same as, hey, I'm going to have a baby.
Right. Yeah. This is an important topic. It comes up a lot. We feel a lot of questions on this topic, and it seems like no matter how much we talk about this topic, employers still have a hard time understanding and complying with requirements. So the goal with this webinar is to provide a tool or a reference that everyone can at least get some familiarity, or at least get some updates or some answers to their questions. So to answer your question, Linda, what does it mean to be disabled by pregnancy? Well, that's a question that's up to the employee and the employee's doctor. It basically means that the employee is not able to perform the employee's essential job functions, take a step back. The employee is not able to perform the employee's essential job functions due to being pregnant. PDL, we're speaking specifically about California PDL. And in California, all employers with 5 or more employees are subject to PDL, which is going to be most employers in the state. So any employee that is pregnant with an employer of 5 or more employees is going to have PDL rights. And there are no eligibility requirements for PDL. So as soon as an employee is pregnant, that employee has PDL rights. For example, we can contrast this to paid sick leave, where an employee has to be employed for at least 90 days before taking any kind of paid sick leave. It's not the same with PDL. PDL, an employee is eligible for PDL rights on the first day of employment. I've several times received a call from clients saying, we just hired an employee. It's her first day. She told us she's pregnant. What do we do?
That happened to me, Curtis.
Happens all the time.
We hired a new employee, and she called me last week. She's been around about a month, and she called me last week and said, hey, guess what? I'm pregnant. And I said, great, that's life. Congratulations. Right. It's like, yeah, it's a hiccup for a small team, but we're certainly going to support her. Right.
Absolutely. And that's the correct answer.
Right. Whether you like it or not.
Yeah, whether you like it or not, you're going to support the employee.
Some of our clients don't like that answer, but yeah. So like Curtis said, like that's one of the things that I think is confusing to some people, because when we start talking about FMLA and CFRA, they do have some eligibility requirements, right, in terms of length of service, but you don't when it comes to PDL. So from day one, an employee is covered under this law. And so when we talk about disabled due to pregnancy, Curtis, like you said, we always go by what the doctor says, right? We don't take a woman's word for it. We don't take a third party's word for it. It's whatever the doctor says. But it can also include things that you might not necessarily think of. Like we always think of like, okay, she's going to be out for a period of time because she's going to have the baby, right? But what kinds of things have you seen that are covered by PDL other than the specific like day of childbirth, right?
Right. So PDL is going to cover primarily, in addition to taking time off to have the baby and recover from delivery, PDL is also going to cover any kind of doctor's appointments leading up to pregnancy. And pregnant employees typically have regular monthly checkups. And if there's any kind of complications, or if the employee is sick or having trouble, the doctor's visits may be more frequent, maybe every 2 weeks, maybe every week, or the employee might have to go in once a week for stress test monitoring. Any kind of doctor's appointment, any kind of event where the employee has to go to the hospital or a clinic or the doctor's office, and it's related to the employee's pregnancy, that's going to be covered by PDL and it's going to be protected. And it's also going to apply to any kind of morning sickness or hyperemesis. If the employee wakes up and is feeling absolutely terrible and can't go to work, that employee is absolutely entitled to protection under PDL.
Right. And that's like one of the challenges is actually tracking that kind of stuff, right? We've had situations before. I can think of one employee who, while she was pregnant, she had restrictions on what she could eat. And we had to adjust her schedule and give her some additional time during the day to go back to her apartment so she could like cook her own food. right? And so it was part of her pregnancy. We have a doctor's note to that effect. So we adjusted the schedule accordingly, right? So
Absolutely.
it can show up a lot of different ways. The other thing before we move on to the next slide is, PDL does not cover baby bonding. So this is really specific to when you're disabled due to pregnancy. And again, that's when the doctor says, hey, you shouldn't work for whatever reason related to your pregnancy. Probably the biggest issue that I see, I don't know about you, Curtis, is I hear women say all the time, and some employers don't know this either, right? I hear women say, oh, I'm going to have a baby, so I'm going to take 4 months off, right?
Well, pregnancy disability leave guarantees leave of a maximum length up to 17 and a third weeks or 4 months or 692 hours.
To be specific.
To be specific. And it's prorated. If you have a part-time employee that only works 20 hours a week, it's prorated to 346 hours, right? So, but it's only if the employee is disabled due to pregnancy. And how do we know if the employee is disabled due to pregnancy? Because the employee gives you a doctor's note that says employee cannot come to work. I have a friend that works for a very large employer who is very good at pregnancy disability compliance. And she worked until she delivered. And about 2 days after delivering, she went back to work. She recovered quickly and she wanted to go back to work and she didn't want to take time off. And as long as her doctor said that was okay, then that's okay. Right. My wife just delivered our second baby last November, and she took 17 and a third weeks off because her doctor said that she was disabled for those 17 and a third weeks for those 4 months. And so my wife took the full 4 months off. It depends on the situation. There's no tradition. There's no what commonly happens. It's whatever the employee and the employee's doctor say is going to happen.
Yeah. And one of the things about pregnancy disability leave and most of the other laws we're talking about, this does require the employer to put the woman into the same position when she returns. So there are a couple of exceptions to that, but we're not going to go through a lot of the detail on that. But just in general, think I need to put this person back in, which can be, again, an issue that has to be managed well, right? You can do it with temps. Maybe somebody else can, you can divide up the workload for a period of time. So it's not, without pain, but it's a pretty big burden to say, I don't need to bring her back. Right. So Curtis, one of the exceptions to that, which does come up every once in a while, is what if there's a layoff?
Yeah, every once in a while there are some very narrow exceptions to the requirement of reinstating the employee. If you ever think, if a client, a company, a business ever thinks that they're qualify for one of those exceptions, they need to call their counsel, their labor attorney, and discuss those situations. Because even if a company is going to lay off employees, the company still needs to explain why the employees that got laid off were the ones that got picked. So if there's a team of 20 people and 10 of them are going to get laid off, why did you pick those 10? All right, there have to be bona fide, non-discriminatory reasons why those 10 got picked. And if there's an employee who's on pregnancy disability leave, that's a part of that team, you need to talk with your counsel about whether that employee gets included in that list of 10 or that employee's job gets protected.
Yeah, definitely. And the other thing that comes up sometimes that I want you to talk about is, this last line where it says transfer rights. Because what happens if a woman comes in with a note from the doctor and the doctor's not saying that she cannot work, but the doctor is saying, oh, she can't do this particular job?
Yeah, so even though PDL is primarily all about being disabled due to pregnancy, PDL also has terms relating to reasonable accommodation or transfer rights if the employee is affected by pregnancy. So affected by pregnancy and disabled by pregnancy are different. So like Linda said, an employee is not disabled, the employee can still work, but the employee is affected by pregnancy and can work, but needs to be transferred to a different position so the employee can work. An example off the top of my head would be could be an employee who does have that severe morning sickness or hypermesis and is easily triggered by certain smells and needs to be transferred to somewhere else where she's not exposed to those smells so she can work and do her job. And when faced with a request for a transfer, you basically treat this like any other accommodation request. You have to go through the good faith interactive process to determine if the request is reasonable, the request for a transfer is reasonable, or the request for an accommodation is reasonable, and whether the company can provide that accommodation.
Absolutely. Let's look at the next slide because we have a few more on PDL specifically, because this is the main law we're talking about, right? So one of the things to keep in mind that you do have notice requirements, and the notice requirements are different for PDL than they are for FMLA and CFRA. So when we start talking in a few minutes about which laws run concurrently, just keep that in mind. So in this case, you do have to respond within 10 days when you find out the employee is requesting a leave of absence, or you have knowledge, I should say, that the employee may need a leave of absence, right? And then once that leave is approved, you can make it retroactive to the first day of the leave. If the woman's out, maybe she goes out, she's not feeling well, and then a week later she says, "Oh, my doctor's gonna, told me I have to be bedridden," or something like that, then you can make it retroactive. You have to provide them with a notice that sort of spells out their rights and their obligations while they're on a leave. And you can require doctor certification like we've been talking about. So we always advise our clients, you go by what the doctor says. And if for some reason you think that doctor's note is fraudulent, you have the right to send them to a doctor of your choice. Rarely, if ever, have we taken advantage of that. We usually just roll with whatever the doctor says. But you can require that. And I would make it a practice, in fact, of requiring for any kind of leave of absence, a doctor's note specifying that the employee cannot work. And then you want to make sure that you're tracking all of that time off. So Curtis, let's talk about vacation and sick. When can an employer require the use of either one of those?
Yes, the PDL law is expressly states that an employer cannot force an employee to use vacation while on PDL. Doing so would be pregnancy discrimination. The employer can give the employee the option to use vacation while on PDL, because PDL is otherwise unpaid. So the employee has the option to take vacation, but the employee cannot be forced to take vacation. When it comes to sick leave, the law is clear here that an employee can be required to use paid sick leave while on PDL.
Right. But if you combine the two into PTO, then no.
Then no. Then you have to follow the paid sick leave laws.
Yeah. And you said a second ago that pregnancy disability leave is unpaid. Just to be specific about this, unpaid by the employer.
By the employer.
Right.
Correct.
So when we talk about leaves, one of the things I always advise is separate time off from pay, right? Completely
Correct.
two different concepts. So don't try to link them together. So the first thing you're going to do is like, which leaves apply, right? Which leaves do I have to provide to the employee, and how much time could they potentially take? And then the follow-up to that is, okay, is there any way for them to get paid, right? Is it disability? Is it paid family leave? Is it vacation? Is it sick? Is it whatever, right? So you go through all of those options with the employee, but keep those conversations sort of separate. How much time do they get off? And then is there any sort of pay available to them?
Yeah, and that's very important to know, because oftentimes I get calls from a client, and the client says, I have an employee that wants to go on SDI, and SDI is not a form of leave of absence. It's getting supplemental income from the state when you're disabled. So it's very important to make that distinction, that the right to not go to work and the right to get money are separate rights. They're separate conversations.
Absolutely. And then while the woman's on her disability leave, you are required to continue any sort of group health benefits that you have in place as though she's continued to work. So that does mean that the employer is going to pay their portion that they normally contribute. And it also means that she has to pay her portion that normally would have come out of her paycheck, right? So you do have the possibility of a few different ways of handling this. One, you could go to her and say, you know what, why don't we double up on premiums between, like if the
if you know ahead of time, right? Why don't we double up on premiums and you can authorize that deduction to come out ahead of time so that when you are on your leave and you have only SDI as income, you don't have to worry about it, right? That's one way to do it. You could just say to her, hey, every month that you're out on your leave, write us a check in this amount, right? That's another way to do it. Just keep in mind that if it's done that way, it's going to be post-tax, while the premium deductions out of her paycheck most likely are pre-tax. So there's a little bit of a difference there. The other option is when she comes back to double up on the premiums or have her pay it back at that point in time. So there's different ways to do it. It's really more about what you're comfortable with and also what the employee can do. If the employee is getting paid sick pay in this example, you could take the deduction from there. It's just a matter of how much, sick time they would have available, and would that cover the amount of the premiums during the leave of absence. So, we can help you think through those options if you want. Also, just keep in mind, you can go after the employee if they don't come back for their leave, and if they still owe you premium, it's just, is something most employers are reluctant to do. So just think through those different options. So Curtis, let's move on and talk about Family Medical Leave Act. So we're now talking about a federal law, right? But it does have some overlap in terms of pregnancy for California employers. So why don't you start us off talking about this?
Right. So like you said, federal Family Medical Leave Act is federal law, and it also applies to certain events that PDL applies to, such as the birth of the child or a serious health condition of the employee. FMLA only applies to covered employers, and covered employers are going to be employers that have 50 or more employees within a 75-mile radius of a working location. All right, so that's how an employer becomes covered. And then if an employee works for a covered employer, that employee is eligible for FMLA if all three of these elements are met. The employee must have worked 1,250 hours in the 12-month period prior to the leave of absence. The employee must have worked at least 12 months for the company, and the employee must work at a facility or location with 50 or more employees within a 75-mile radius of that working location.
So I think a lot of our clients are probably aware of that. I think sometimes they forget that family medical leave and the pregnancy disability leave law actually can run concurrently, right? And so that's a big difference. And again, we're going to show you a slide to show the overlap and the interplay on these in a little bit. So the length of leave available is also different from PDL because FMLA allows for 12 weeks in a 12-month period, right? So you can take it intermittently, you can take it all at one time, however it works out between you and your doctor, right? So again, if you're, right, this does cover pregnancy, and the job is still guaranteed, right? So we've talked about those things before, and similarly, if the need's foreseeable, 30 days notice should be given to the employer.
Yeah, there's a number of similarities with FMLA. So generally speaking, as long as the employer is compliant with the PDL rules, the employer is probably also going to be compliant with FMLA. But it's important to remember FMLA compliance. And it's also important to remember to designate the leave as both PDL and FMLA.
A great segue into our next slide. So yes, and keep in mind, one of the differences in FMLA and also for CFRA, you have to designate the leave within 5 days of the request. So remember I said the pregnancy disability leave, you have 10 days, but under FMLA and CFRA, you only have 5 days. So you want to make sure that you do it within 5 days so you can count that time against the FMLA entitlement. So there's a long list of things that have to be included in the designation notice. You can download sample forms from both the state of California and also from the federal government, but there has to be things like, when you're going to start the clock ticking and, how many hours are you going to count against their leave and things like that, right? So you need to go through and then, tell them, is their job protected? Almost always yes, right? What's going to happen with their insurance benefits, their other benefits, can they take sick, can they take vacation? All of those different things need to be in this form given to the employee. And then on this one, Curtis, talk to us about requiring the use of sick or vacation.
Yeah, FMLA is a little different than PDL. Typically under an FMLA leave of absence, the employer can require the use of vacation. But since we're talking about pregnancy, when FMLA and PDL overlap, when they run concurrently, the employer must comply with the law that's more strict. So, and then that in this case, it's going to be PDL. So as long as the employer follows the PDL rules for use of vacation and sick, then the employer will also comply with FMLA.
Right. So on our slide here, it says the employee may elect to use either, and the employer may require the use of either. But if it's a pregnancy disability leave, then you cannot require the use of vacation.
Correct.
Now, what I tell clients, though, is you can allow the use of vacation, right? And from my point of view, that's smart, because otherwise they're going to come back from a pregnancy disability leave and turn around and say, now I want to take, 2-3 weeks vacation, whatever they have, right? So if they want to use it, it could be a win-win for both parties, to allow that to happen, but that's an employer's choice. And then the benefit portion is pretty much the same, right? You can stop the accrual on vacation and sick and things like that. But in terms of group health benefits, you have to leave those in place as though the employee is still working.
Yeah, and I just want to emphasize, like you discussed before for PDL, make sure that you arrange for the employee's payments before the employee goes on leave. I've had many times where the employer calls me up, the client calls me up and says, well, the employee owes us $2,000 worth of premiums. What do we do?
Right.
It's an easy situation to avoid if you just arrange with the employee ahead of time what you're going to do.
It is. And most employers don't want to go to small claims court, which is really the only way you're going to get that money. So better to get it up front. Okay, let's switch again and now talk about California Family Rights Act. This is where people's heads are going to explode just a little bit. So we're going to go through this because this is where it gets confusing. Again, if you have 5 or more employees, you're covered, similar to PDL, right? But California Family Rights Act, when it went into place after FMLA, they tried to sort of model it after FMLA. But then it was like, well, wait a second, we have this law already that provides for pregnancy. So they carved it out of CFRA. So it does not cover pregnancy. Okay, so I want to be really clear about that. So you can run PDL and FMLA concurrently if you have 50 or more employees, but you do not run PDL and CFRA together, meaning you don't count any sort of time off allotment against their rights under CFRA.
Yeah, so what basically ends up happening is the employee has the PDL rights, and then when the employee is no longer disabled due to pregnancy, the employee then potentially has CFRA rights. And the primary thing that employees, the primary rights that employees seek from CFRA after they're no longer disabled due to pregnancy is the bonding or new parent leave. And bonding or new parent leave is specifically for the birth of a child, the adoption of a child, or the placement of a child, of a foster child with a family. And these rights are available in the 12-month period from the date of birth, adoption, or placement.
Right. So a lot of times a woman will go out on pregnancy disability leave, and this is where that 4 months gets confused, right? So I just had this come up with a small employer. She just gave the woman as much time as she wanted, essentially, and it turned out to be almost 6 months. But by that time, now the woman wants to take, her baby bonding under CFRA, and she used way more than what she was entitled to under the law, but the employer didn't designate the leave properly, right? So now we're sort of starting the clock ticking on CFRA way after the fact, right? So that woman can now take up to 12 weeks, and it does not have to be concurrent either. So, the woman may want to give birth, and as soon as the doctor says, okay, you can go back to work, immediately start taking baby bonding and stay home longer. And that's fine under this law. She could also say, you know what, I'm going to take a couple more weeks under this for baby bonding. And then I'm going to baby bond again at Christmas. And then I'm going to baby bond again next July. Like whatever the woman wants. This one does not require the same type of notice. I mean, you have to provide notice, but it doesn't require like a doctor's note to say, oh yes, you can take time off for baby bonding. Basically, if you have knowledge that she gave birth, then she has up to the 12 months, or adopted, she has 12 months from that date forward to use this. And then Curtis, what do you want to talk about in terms of length of leave or anything. It's pretty much all the same as
Yeah,
FMLA.
it's similar as FMLA. The eligibility requirements are pretty much similar. The employee still has to have been employed for 12 months, and the employee still has to have worked for 1,250 hours in the previous 12 months. The 75-mile radius requirement was recently eliminated from CFRA, so we don't have that anymore. But like Linda said, as long as the employee is eligible for CFRA new parent leave, then the employee gets 12 weeks in a 12-month period of CFRA new parent leave.
Right. And similar to the other laws, you do have to designate the leave, meaning you have to notify the employee in writing of her rights and obligations under this leave and when you're going to start the clock ticking and how much leave is going to be, how you're going to count that leave against her annual entitlement, right? And this is the biggest mistake. One of the biggest mistakes that we see on this is where you don't start the clock ticking. So like the example I just told you with our small client, right? She's got 5 employees and one of them went out on pregnancy disability leave, but it was never designated properly. And so now when the employee wants to take additional baby bonding, here we go, right? But it's way after the fact because she already really bonded with her child, but out of the grace of the employer, right? Just because the employer didn't know to designate that leave. So again, you're going to go through and you're going to respond to the employee within 5 days if you need additional information, like maybe the employee just tells you. And so you're like, well, it sounds like you're entitled to a leave, but really before I can designate the leave, you need to bring me a doctor's note that says, that you are disabled due to pregnancy or that you will be at some point in time. Anything else you want to mention in terms of the designation, Curtis?
It's just that it's important to do, like you said.
Yeah.
Like you said, you had the situation with your small client that wasn't designating and then got into some trouble. I've seen some of the situations many times. It's important to designate and count.
Exactly. So the effect on benefits is pretty much the same, like we've been saying. It's best to try to arrange payments before the employee goes out on leave, but it's up to you on how you want to do that. Just keep in mind, obviously, you're not going to be looked at with much favor if you try to invoke the cancellation provisions under FMLA or CFRA while a woman's out having a baby, right? Say, oh, well, you didn't pay me within so many days, so I'm going to cancel your insurance. So you don't want to do that. So it's best to make arrangements ahead of time. And usually most women that I've talked to appreciate that because they'd rather make those payments while they have an income rather than when they're limited to their SDI benefits, right? So that's important. And then what about vacation and sick on this one?
Same. So similar rules to FMLA. Since the employee is no longer disabled due to pregnancy, we don't need to talk about the PDL limitations. But so to get back to your question, similar to FMLA, the employer can require the use of vacation while the employee is using CFRA leave, and the employee can request and use paid sick leave. One thing to note here is that when an employee is disabled due to pregnancy, the employee may be eligible to receive disability income from the state. Once the employee is no longer disabled, the employee is no longer entitled to receive disability income from the state. But if the employee is then using CFRA new parent leave, the employee is eligible to receive paid family leave from the state, which is available up to 8 weeks. I believe it was just extended from
8
6
weeks. Yes, and that's a good point. So paid family leave is the PFL abbreviation we have in that top line. And so while she's disabled due to pregnancy, she's going to collect state disability insurance. Once she's no longer disabled, but she wants to continue baby bonding time, that's when she would then apply for paid family leave. And then she would collect that for up to 8 weeks. So she's entitled to 12 weeks. But the pay is up to 8 weeks. And so that's what we're saying. You always separate those two issues, talk about how much time off do you have coming to you? Oh, it's 12 weeks. And then, oh, okay, is there any pay available? Yes, well, we can talk about vacation and sick, but also you can apply for paid family leave. So that's the difference on that one. Now let's look at how these run concurrently or don't, depending. So for pregnancy, while you're disabled, pregnancy disability leave and FMLA run concurrently. Then when you move to the baby bonding stage, if there's any remaining FMLA, it runs concurrently with CFRA. And then pregnancy disability and CFRA do not run concurrently, right? Because again, there was a carve out in the CFRA regs for pregnancy. So you're only going to start counting time against CFRA after the disability period ends. So if we just take a look at a chart for those of us that are visual, right? Let's just say the woman, is going to go out on pregnancy disability leave, starting in January. And if she's going to take the whole 17 1/3 weeks, because she's disabled that entire time, okay, that would run through the first 4 months, right? FMLA will get exhausted after 3 months, so that doesn't apply anymore. Once the baby is born, then CFRA is going to kick in for the baby bonding. So potentially that woman could be out from January 1st, let's say, until the end of July, right? Depending on how that all plays out, if she's disabled the entire 17 1/3 weeks or just a period of that. Normally, for most normal pregnancies, it's going to be 4 weeks before and 6 weeks after the baby's born, or 4 weeks before and 8 weeks after it's a cesarean section, right? But as Curtis and I have said, there are times when a woman's going to be disabled for longer due to severe morning sickness or, postpartum depression or something that happens, right? So I'm sure there's going to be questions about this. If you have them, just remember, drop them in the Q&A section, and we can address those when we're done with our slides, which will just be in another 5 minutes or so. And then Curtis, you want to talk about how the ADA comes into play here?
Yes, absolutely. And this is going to be related to the FEHA slides that come up in just a few minutes. So there are times when an employee uses the 17 1/3 weeks, uses the 4 months of PDL, and then the employee uses 12 weeks of CFRA, and the employee may still be disabled or otherwise unable to come to work. And the employee calls the employer and says, I still can't come to work. Here's a note from my doctor. And the employer calls me and says, what do I do? Well, if the employer is covered by ADA or FEHA, then after PDL is over, after CFRA is over, the employer is obligated to treat the employee like any other similarly situated employee. So if an employee is still disabled for whatever reason after PDL, after CFRA, then the employee may still be entitled to a leave of absence under ADA or FEHA.
And just to be clear there, Curtis, the CFRA wouldn't apply in terms of the disability portion, just for baby bonding, right?
I've seen it happen, but
okay, so that's got to be a weird exception, but
Yeah.
anyway, so if the woman is still disabled due to pregnancy, or maybe she, we've had situations where a woman's taken out and told complete bed rest during her first or second trimester, right? So clearly she's going to exhaust the 17 1/3 weeks. To Curtis's point, what you're not going to do is say, I'm sorry, you've exhausted your pregnancy disability leave. It's been 4 months, so now we're going to fire you, right? You're not going to do that. You're going to have a requirement to reasonably accommodate that additional time off. The length of leave is not specified in the law, right? So again, we're going to go back to what the doctor says. The doctor says she needs additional time off for whatever medical related reason, then we're going to grant her that additional time off. There's going to be certain exceptions. And again, call Curtis with those questions or call us with those questions, because it's not something you should just take lightly, right? So that's why you should care about this, is just because after the PDL ends, it could delay the start of CFRA, and it could require you to continue to employ that person longer. So then FEHA, the Fair Employment and Housing Act, Curtis, the difference here also is where ADA covers employers with 15 or more, FEHA covers 5 or more.
Correct.
So everything is pretty much the same, right? It's not specified. You have to give notice, pretty much job protected. So just keep in mind, those other laws do come into play like they would for any other leave of absence if the person exhausts their FMLA or the CFRA and they still have some, or if they're not even qualified yet for either of those leaves, right? they might be qualified for pregnancy because it kicks in with day one, but they might not yet be qualified for FMLA or CFRA, either because of the size of the employer or the length of service requirement. And so again, you're not going to fire them. You're going to give them an accommodation leave essentially under one of those two. So can you talk a little bit, Curtis, about the difference between ADA and FMLA when it comes to serious health conditions? Because that's a term of art.
Yeah, the idea here is that ADA is not necessarily going to run concurrent with FMLA. They're essentially different concepts, but FMLA is specifically for the purpose of birth of the child or for a serious health condition related to that. Another idea is that the employee may be pregnant and have FMLA rights, but not substantially impaired or not substantially limited in what the employee can do.
Yeah, so again, if somebody brings you a note and says, I need additional time off, it's beyond whatever you think is required under the law, just contact somebody and discuss that. And then our last slide before we take any sort of questions and answers, Denise, so hopefully people are dropping those into the Q&A. The last slide is just talk about the interactive process for a little bit, because, you know, this comes up a lot for a lot of different reasons, right? But Curtis, maybe you can just talk about some of the obligations under the interactive process, and we can talk about the steps and what has to be done.
Yeah, just keep an open communication. I'm going to speak generally. Just keep an open communication with your employee. I mentioned before, my wife recently delivered last November, and while she's been out on work, she would periodically get calls or texts or emails from her immediate supervisor, just checking in, just to see how she's doing. Let's see if there's anything that her boss could do for her. It doesn't need to be complicated. It just need to stay in contact.
Yeah, and anytime somebody has a doctor's note that says, I'm limited in some way, I can't work, or I can only lift 5 pounds, or I can only work 2 days a week, or whatever those restrictions are, that's really when the interactive process is going to kick in, right? So the employee is going to have an obligation to bring something in writing from their doctor, if you ask them to, that has whatever those limitations are. And then at that point, as an employee, you're going to sit down with them and discuss, okay, what is an accommodation that could help with this, right? And it's incumbent upon the employee to spell out, like, well, I need to be able to come in, work later, or like the case for one of our clients I was discussing earlier, where she needed additional break time to go back to her apartment so she could cook her own food, and we arranged her schedule accordingly, right? So she could cook breakfast in the morning before she left, and then she could take an earlier lunch to go eat again at a certain time. And, you know, so you just work it out and you just say, okay, is it a reasonable accommodation? This is what we can do to help this person out and, allow them to continue working. And then you just want to document what those steps are, and probably also put in there that we're going to try this and see if it works, right? Don't have to necessarily commit for the rest of eternity when you first have that conversation. And Curtis, we did an interactive process webinar. I don't remember if it was last year. I think it was last year though. Yeah. So yeah, if you have questions about the interactive process, you certainly can reach out to either me or Curtis, but you can also go out and watch that webinar. Was there something you wanted to add to that, Curtis?
Yeah, I see so many times where employers will treat the subject with their pregnant employee as a very sensitive subject, but I don't think you need to. I mean, they walk very delicately, like walk on eggshells, because they're so paranoid or worried about violating the employee's rights or upsetting or angering the employee. I don't think you really need to. I think when you have an understanding of what your obligations are as an employer, you can just have frank, honest, and open conversations with your employee. And like you said, just keep it simple and work it out. You don't need to walk on eggshells. You don't need to be delicate. I think if you understand if you know what the employee is entitled to, then you can have those conversations in just a frank manner.
Well said. Denise, what questions do we have? Unmute yourself and share with us.
Okay, so we have a couple questions that came in. One question that came in back when you guys were talking about PDL leave on slide 11. You talked about the period of disability is up to 4 months and 17 weeks per pregnancy. Does it matter how many employees you have for that PDL leave?
Yeah, it's 5 or more. It's 5 or more. So if you have under 5, then you don't necessarily have to give somebody a pregnancy disability leave, although I don't know, I personally would. I don't think I would fire the person, Curtis.
Yeah, same here.
Yeah. So, but technically you're covered at
It's
5, similar with CFRA.
Even though there's the pregnancy disability leave law, you still can't treat somebody differently because of their gender or their sex.
Right.
So I still wouldn't do it. I'd still give them the accommodation even if you have fewer than 5 employees.
Yeah.
And the requirement of providing up to that maximum, that available time of 17 1/3 weeks is for all covered employers. So even if you have exactly 5 employees, you're still required to provide that up to 4 months.
Yeah, we've had some interesting situations over the years with clients. I remember working with a large client before. Wow, this was early on after I started my business. So it probably goes back 14, 15 years. And it was a large employer that did property management, and they had a business, or a building, I should say, in San Francisco, and they had like one property manager, right? And she got pregnant, but they were clearly subject to every law because they had, thousands of employees. And so that was a big challenge, right? Because how do you cover that one employee? And so, of course, like the first instinct is, oh, I don't want to offer the leave. It's like an undue hardship.
Mm-hmm.
It's like, well, but could you hire a temp? Could you transfer, an employee from a building that has multiple people over there? There's like, you can get creative about it. And in the interactive process webinar, we also talk about a website called Ask Jan. It's the Job Accommodation Network, so askjan.com. And it's really helpful. And you can actually call and talk to them about, ideas for accommodation if you're stuck, right? Like, what are some possible ways we could accommodate that request?
Okay.
Yeah.
Sorry, Curtis, finish.
Yeah. When it comes to counting the employees, it's counting actual people working it. It's counting heartbeats. A lot of times the owner of the business is also working in the business. It's very common in the small business situation. And when the owner is working in the business, that owner is counted as an employee. It's counted in that 5. And there's no differentiation or distinction for part-time or full-time. If you have 5 people receiving checks, then you're covered by a PDL.
Yeah.
Curtis, you're one step ahead. That was going to be my next question. Seriously, the question was, I have 4 employees, 3 full-time, 2 part-time. I'm also on payroll. Does that make 5? So you just answered that question. So way to go, Curtis.
He's psychic.
He is psychic. Do we need to fire someone else to accommodate a transferred pregnant employee?
Did you say fire?
Yeah. So
I think they're saying, like, we talked about if somebody's pregnant and can't fulfill her job duties, but the doctor says, oh, she has these restrictions. And then we say, oh, okay, well, we could put you in this other role, but will we have to fire the employee that's currently the incumbent in that other role to make room for the pregnant woman? Does that make sense?
Yeah, you would have to do an analysis of whether that transfer is an undue hardship, whether that transfer is reasonable. So just because an employee is affected by pregnancy and wants a transfer, the employee is not guaranteed or promised a transfer. You still have to go through the good faith interactive process to determine whether the requested accommodation is reasonable or an undue hardship. Firing somebody else might be an undue hardship. But
would be for that person.
Yeah. So I can't give a definite answer to that question, but you still have to go through the framework of analyzing the situation.
Okay. Does FMLA and PDL have to run concurrent? Because there's a lot of acronyms you guys are talking about today.
Yeah, for sure. But does it have to? I don't know why you wouldn't want it to.
Right.
Because otherwise what happens is if you go out on pregnancy disability leave, for example, and she's gone for up to 4 months while she's disabled, right? But you have not designated under FMLA, then once the baby's born, she could potentially take another 12 weeks off, right, for baby bonding or whatever. And then she could under CFRA take another 12 weeks off for baby bonding, right? So you could have a woman gone pretty much the entire year unless you designate the leaves properly. And so what they run concurrently when they're able to run concurrently.
Okay. Does an employer have to continue paying health benefits when employee is out on pregnancy leave?
Yes.
Yes, the employer continues to pay for the portions that the employer has already paying under the employer's plan, and then the employee continues to pay the employee's portions. So if the employer is already paying 100% of the premiums, then the employer will continue to pay 100% of the premiums.
Okay, great. FMLA, does it apply if you have less than 50 employees?
No.
Negativo.
No, but keep in mind that a couple years ago, I think 2, maybe 3 years ago, CFRA dropped from 50 employees down to 5 employees in California.
That's
Denise, while you ask some additional questions, I'm just going to move it to our thank you page.
Yes.
So in case anybody drops off, they have this information as well. With our next webinar, we're going to be talking about Secure 2.0 because it made some changes to retirement plans. We have a special guest speaker who's an ERISA and benefits attorney. So she's going to give us the highlights of what changed. And then if you need HRCI credit, there's a link to the webinar survey down there. Now back to you, Denise.
Okay, great. Does CFRA apply to men for baby bonding?
It does.
It sure does.
Love that answer.
We're seeing a lot more clients be very, I don't know what the right word is, thoughtful or progressive or whatever they want, but they're instituting paternity policies and really making sure that men have the benefits available to them as well.
Well, it's a tough employment market right now. So employers have to be competitive.
Right.
They have, if employers have good talent, and then the employers need to come up with ways to retain that talent. And if it requires a paternity leave policy, then.
Yeah, I have one client that actually they wanted to cover the woman's leave and pay the difference between SDI and her full salary. And so then it opened up the discussion about, okay, do we now have to do that for men too? Right. Sure. You know, and I said, well, if the man's not going to have the baby,
it's not going to be disabled.
Right. It's not going to be disabled. But if you choose to make up the difference between paid family leave and the regular salary, then yes. Right. Because the man's entitled to PFL, you know, paid family leave benefits, just like the woman is for baby bonding.
Does a man qualify for FMLA if he's an employed less than 1 year with the company?
No.
Negativo.
Nor is the woman.
Okay. This one is a acronym soup here. So if we have
abbreviation soup, yes.
Yeah, abbreviation soup. Okay. If we have a new employee and they go out on PDL, they are only entitled to those 17 1/3 weeks and cannot add additional leave through FMLA or CFRA as they do not meet the 12-month service requirement. So
that's a possibility. And that's what we were talking about before. So that's when you have to look though, is it a reasonable accommodation to extend a leave of absence or to provide like a medical accommodation leave, we often call it, right? So they may not be entitled to a leave of absence under a specific law, but the ADA and FEHA both say, hey, you have to reasonably accommodate somebody that has a disability or has a serious medical condition, right? So you might have to look at that.
Okay.
But again, let's step back for a second. So let's take like my employee who's going to have her baby in September, right? By the time the baby's born, she will have only been with us, let's just say 6 months. Okay. She's not yet entitled to CFRA or FMLA. So she's not entitled to baby bonding per se, but she would have a year from the time the baby is born to take her 12 weeks of baby bonding. And by next March, she would be then eligible for California Family Rights Act. Does that make sense? So when she goes out on leave, it's going to be designated under PDL only because she's not entitled to any other leave. Once the doctor says, okay, now you can go back to work, she would not yet be entitled to baby bonding under CFRA because she hadn't worked for us for a year. But then next March, when she hits her 1 year, right, then she would have another 6 months to take baby bonding if she wanted to. Hopefully that didn't make anybody's head explode. It gets confusing.
I liked it.
Yeah, there you go. The more complicated, the better, right, Curtis?
Mhm.
Yeah.
This is why we always say, call one of us, right? Let us help you figure this out because it does get confusing. Which laws apply, which laws you're subject to, which laws the employer eligible for, like all of that, what the requirements are.
Yeah. Very much different than it was years ago. Okay. When is day one considered for PDL?
When the
PDL leave.
person goes out on leave due to disability.
Yeah, I did some research on this past week, Linda, because I've had this question before, and the laws, I don't think the law is very clear on this.
Oh,
Because, well, so your answer is absolutely correct. So it's whenever the employee is first disabled due to pregnancy. But the question that I had that I was trying to find an answer to is whether that period of eligibility to use PDL goes back to day one of pregnancy or the first day of when the employee had symptoms or a doctor's appointment or some other disability.
are you talking about the ability to like retroactively
the
designate
ability
it?
to retroactively designate. Yeah.
Yeah.
I couldn't find anything that says you can go back or that you are required or should go back to day one of pregnancy. But I think
that
what you said before is right. Yeah, I think what you said before is right, that it's going to start whenever the employee is first disabled due to pregnancy.
And again, that's going to go by a doctor's note.
Well,
so
correct.
Mm-hmm.
All right, Denise, bring it home. Do we have one more question?
One more question. So if the company qualifies for FMLA, but the salary employee is just under that 12 months and hour requirement, are they still required to give FMLA time?
Well, they wouldn't be necessarily like sort of my example I was just giving with our employee, right? She's not eligible yet for FMLA, or well, she wouldn't be for FMLA anyway, because we don't have 50 employees, but she wouldn't be eligible for CFRA at the time the baby's born, but she will be 6 months later, right? When she hits her 1 year mark. So we do have this come up on a lot of different types of leaves where the person has maybe been there 11 months. They're not yet eligible for CFRA or FMLA, right? But they will be. So the question is, do you reasonably accommodate them for that? Let's call it the 12th month of employment, right? Once they hit their 1 year anniversary, now they are eligible under FMLA and CFRA for those benefits, right? So I don't think you ever want to fire somebody in their 12th month of employment and say, sorry, we're not going to give you a medical accommodation leave because you haven't been here a year, right? So you would want to put them out on leave, but you're going to want to remember as soon as they hit their 1 year anniversary, anytime taken after that, you're going to want to give them the proper designation forms so you can start counting that time against their 12-week allotment.
That makes sense.
Yeah, I agree.
That makes sense. Okay, with that, I believe we are over. Please make sure you got the contact information for Linda and Curtis if you have any questions. Linda mentioned we have another webinar coming up, so we'll send that information out. And I know it gets posted on LinkedIn. And if you need HRCR credit, please complete the survey. And if you don't get that, we have notifications of everybody who wanted the HRCI information. So if you don't get it, you can reach out to us. Thanks.
Yes, and I'll just add, we're going to send out a follow-up email after this through Zoom. So you'll get one tomorrow, it'll have a link in it. And because we had some sort of issue dropping information into the chat, we'll make sure the links for the downloads are also included in that follow-up email so you can get copies of the slides and the other handout. The other handout we put together is a list of all the states with whether or not they have something specific to pregnancy disability leave. So it doesn't go into detail about what it is, but if you look on the list, for example, and you say, oh, Illinois has something, you can then at least go research it. So for those of you that have employees in other states besides California, it should at least point you in the right direction. All right. Thanks, Curtis, so much. Thanks, Denise.
Thank you very much.
Thanks, everybody, for attending.
Have a great day.